Section 3. So Section 3 has three limbs. Section 3(1) says that no person shall enter into Benami transaction. So as the name indicates, prohibition of Benami transaction, subsection 1 is very important. It prohibits any person from entering into a Benami transaction. Section 3(2) says that any person who enters into Benami transaction shall be punishable with an imprisonment which may be extended to 3 years or fine or both. Subsection 3 says that any person who enters into Benami transaction after commencement of the amended law shall be punishable as per provisions of chapter 7, that is section 53, 54, 55. So section 3 has three limbs. 1 prohibits a person from entering into Benami transaction. Subsection 2 actually covers the situation where the Benami transaction has been entered into after 1988 law, but before the amended law of 2016. And subsection 3 covers the situation where the Benami transaction has been entered into after commencement of 2016 law. Section 5 says that any property which is subject matter of Benami transaction shall be liable to be confiscated by the central government. Under the 1988 law, the words used were acquisition. So acquisition has to be followed by a compensation. So it was not possible to acquire a property without payment of compensation, though there was a clause. But now under the new law, the term has been correctly used as confiscation because the Benami transaction itself has been considered as an illegal transaction. So the property is going to be confiscated and titles and rights will vest in the central government. Section 6 is an addition through the amended law, which is very interesting. It says that if the Benami transaction is entered into, then a property cannot be retransferred by Benamidar to the real owner. So it prohibits the retransfer of property from the Benamidar to the real owner. And it further says that if at all such transaction takes place for the retransfer of property from the Benamidar to the real owner, such retransfer shall be considered as null and void. So just imagine the consequences of entering into a Benami transaction. So once a transaction is considered as Benami, then it is Benami forever. Because the property, as we discussed in the definition, proceeds from the property will be a Benami property. And you cannot retransfer, you cannot rectify the transaction. So section 6 is of immense significance, which is introduced by the amended law. Clause 3.3 says that if the Benami transaction is entered into after commencement of the act, then the punishment shall be as per chapter 7. So what chapter 7 is? Section 53 says that where any person enters into a Benami transaction in order to defeat the provisions of any law or to avoid payment of statutory dues or to avoid payment to creditors, the beneficial owner, Benamidar, and any other person who abets or induces any person to enter into Benami transaction shall be guilty of offence of Benami transaction. So all the parties to the transaction, of course, the intentions will definitely be considered, saying if the mens rea. So provision of any law is defeated or to avoid payment of statutory dues. If all these conditions are satisfied, then beneficial owner, Benamidar, or any other person. So just imagine a situation, any other person who abets. So, I always believe in 99.99% cases, say the client is going to say that, I don't understand anything, I have done whatever my CA has advised me to do. So I have just entered into a transaction. So we receive a phone call, I am entering into this transaction, what should I do? What we usually check, is it going to be a check transaction? Is it going to a bank transaction? Yes, please go ahead. But have we really asked him what is the source of funds, though it is the source through a bank? So, that is like alarming for professionals who are advising clients over phone, and just a casual advice won't do. We need to be serious. We need to check the source of funds from where the payment is going to be made. So if all these conditions are met, then the law says that a rigorous imprisonment for a period not less than 1 year, which may be extended to 7 years, and fine equivalent to the 25% of the fair market value of the property are the consequences. So a person giving false information will also be charged. The person who gives false information knowingly during the proceedings will be punished with a rigorous imprisonment for a period not less than 6 years, which may be extended to 5 years, and fine to the extent of 10% of the fair market value of the property. It further says that no prosecution shall be done without previous approval of the board. So CBDT will have to approve the prosecution before it is launched.